Hi, I'm Stella O'Malley, a psychotherapist in Ireland.
And I'm Sasha Ayad, an adolescent therapist in the United States.
And this is Gender, a Wider Lens, a podcast dedicated to the shifting concepts around gender in our contemporary culture.
Through in-depth interviews, personal stories, and psychological exploration, we seek to open up the discourse around this hot-button issue.
Join us as we look at gender from a wider lens.
Hi, Stella.
How's it going, Sasha? How's life?
Life is good. We have been wanting to get an attorney on to talk to us for a long time, and we finally got to do that today with Josh Payne from Campbell Miller Payne. It was an awesome conversation.
It felt like a really important conversation. We work with so many detransitioners in the Beyond Trans program with GenSpect, where we give funding for therapy for detransitioners and people who've been harmed by medical transition. And again, people talk about the lawsuits. And the detransitioners talk about the lawsuits, and they often sound quite defeated and deflated about it. And I remember a lawyer telling me that they have to realise it's lawyer shopping. They need to realise that you absorb all the options. And when you hear Josh Payne speaking today, you'll see this is just a legal challenge, literally a challenge that some lawyers, certainly Campbell Miller Payne is one of the firms that are going to take them, that if they know what they're talking about, there are lots of opportunities. There's lots of opportunities to take these claims, but you've got to know what you're doing and you've got to act fairly soon, really, with it.
Yeah, and there was a moment where actually Josh shared a monumental piece of news with us for the first time. So we definitely think this is a kind of a must listen. If you're following all the news around gender medicine and everything that's unfolded between the WPATH files and the Cass report and all of this back and forth, he shares a very, very important piece of news with us. And we talk about a lot of things. We talk about, how Josh came into this work, what types of cases they take at Campbell Miller Payne, and some of the challenges, as you mentioned, that detransitioners face when they're trying to get a case into court. And we also kind of talk about some interesting things like the neo-genders and the gender nullification surgeries, like these kind of bizarre legal one-offs that they're still uncharted territory as far as I can tell.
Yeah, I think what's amazing to get, let's say, a firm like Campbell Miller Payne, who have set themselves up for detransitioners to take these cases, and they have taken cases, and they're gaining wins. What's extraordinary about that is it gives heart to people who have been devastated by a medical scandal. And, some of them won't be able to take their case, and they know, and it's a tragedy privately for them. But I think the more we see it as we're all in it together, hoping that some will be able to take a case and will land and will win cases, and that's a win for all of us, the more I think we'll get further in exposing the terrible wrongs that are being done to this population.
Yeah, I'll tell you a little bit more about Josh and then we'll get into the episode. So Josh Payne is a co-founding partner at Campbell Miller Payne, a law firm founded for individuals who were misled and abused, many as children, into psychological and physical harm through the false promise of gender-affirming care. Campbell Miller Payne exists to speak up for these victims, assert their rights, and pursue justice. Josh tells us a lot about his early career, how he got into this work, and so much of his bio will be kind of fleshed out directly in the episode. But prior to law school, he served as an AmeriCorps Vista member of the inaugural staff of the organization now known as Impact America, where he helped launch and coordinate the Focus First Vision Screening Initiative. He's participated in leadership forums for attorneys and is a graduate of the Alabama Leadership Initiative. Outside of the office, Josh enjoys spending time with his family and in the great outdoors. Before we dive into the conversation, we want to take a quick moment and thank our sponsors, GenSpect and Therapy First. GenSpect is an international organization committed to fostering a healthy approach to sex and gender. GenSpect will be hosting the Bigger Picture Conference in Lisbon, Portugal this September. To learn more about who will be speaking at the conference and to order your tickets, visit genspect.org.
Therapy First is a non-profit worldwide professional association of mental health providers who view psychotherapy as the appropriate first-line treatment for gender dysphoria. Therapy First supports psychotherapists working with gender dysphoric youth and young adults and offers public education on mental health and psychotherapy. Visit therapyfirst.org to learn more.
Now here's the conversation. Hi, Stella, and welcome Josh Payne to the program.
Thank you for having me.
Oh, we're delighted to have you. I think it's really important whenever you talk to people about trans issues and you get deep into it, quite quickly people say, well, when the lawsuits start, or these detransitioners need to sue, or the only way people will listen is when there's a lawsuit. And so I think it would be great to do a deep dive with you about this, because it feels the time is now for the lawsuits.
Absolutely.
Yeah, and we know that you, along with some of your colleagues, have started a law firm, Campbell Miller Payne, and you're working, my understanding, is exclusively with detransition lawsuits. Can you tell us a bit about your firm? What made you decide to start working with this population?
Yeah, absolutely, Sasha. We did found Campbell Miller Payne in April of 2023. So we have been open for a little over a year and a month. April 1st, to be exact, was our 1-year anniversary. And the story of how our firm came to be is really amazing, in the sense that none of us, I don't think, were necessarily looking to be put on a mission like this, in such a specific type of helping a specific type of client. A lot of us came from civil litigation backgrounds representing companies and individuals in various types of, as I say, civil matters, disputes, lawsuits in court, and arbitrations. My career has primarily centered on representing large companies and business people, in addition to other individuals and government agencies, actually, as well. I had a stint with the Alabama Attorney General's office earlier in my career, but most of it spent representing companies in business disputes, antitrust matters, intellectual property matters, and various other kinds of what we call complex litigation. So I'm a little bit new to the personal injury context as such, but a lot of the claims that we're bringing on behalf of our detransitioner clients who have been deeply injured are claims that I'm familiar with from my prior experience, including claims of fraud and deceit, and feeling that in a doctor-patient relationship that trust was breached and someone was misled into something that was very different from what they were expecting, what they were told they would be getting. And so that aspect of it is something I'm very familiar with from my business litigation and complex litigation matters. So it is a new endeavor in a way, and it's more of a calling, perhaps, and as I mentioned, a mission than ordinary legal work. You have an individual and their family who you think of all the time, and that's what motivates you to help them seek justice and help them try to send a message that what happened to them is not only not okay, but it shouldn't be happening to others. And this kind of practice should be, a stop should be put to it, and the correct, helpful way of guiding people through the medical process is what we need to see in its place. All of us at Campbell Miller Payne, we've got Jordan Campbell, Ron Miller, myself, Daniel Sepulveda rounds out our attorneys, and Catherine Merrick is our director of operations. We feel this sense of calling, we feel this sense of mission, we feel that our clients deserve really good representation, and that their claims deserve a day in court, and that they have a story to tell, and we're here to help them tell that story and seek justice.
And what made you start it? Did you hear about detransition and did you know your colleagues and say, we've got to jump on this? Was there one story or something? Was there an event that made you say, we're going to start a firm for these people. It's an extraordinary event, and I was so excited we all were, when we saw the arrival of your organization, because it's like, here we go. Now it's going to be taken seriously.
In short, yes, that is how it happened. Jordan Campbell is our captain, I call him. He was the visionary behind the firm, and he worked at a much larger firm prior to this idea really coming on his radar, along with Ron Miller and Daniel Sepulveda. So they had all worked together at a very large firm in Dallas, Texas. I knew Jordan from my days in law school in Virginia at Washington and Lee University, where Jordan was an undergraduate at the time. And then he went on to law school back home in Dallas at Southern Methodist University. And we had stayed in touch and knew each other, kept our personal relationship going, but we also crossed paths after we had gone into the legal profession. And he's the one who really was motivated with this idea of, we all have heard about the problem. We know that this is going on. There are people out there who are being harmed and let down. Is there anything I can do with my legal training? And of course, the answer to that is a resounding yes. But until you have that thought, it's not really something you would ordinarily consider. But through listening to podcasts and doing research, Jordan really felt compelled to at least explore the idea. And after approaching the rest of us, said, yeah, there's not only something to this, but if we have the willingness, we certainly have the ability and the skills and the know-how to be helpful. And that's how our firm was born.
Yeah. We'll come back to talk a little bit more about your firm, but I'm really interested to hear about your clients and the cases that you are taking. So for example, how many detransitioners do you guys have right now? What are some of I know you can't share details, of course, but what are some of the kind of traits or characteristics of a typical client in your firm?
Our clients are so inspirational. And just the fact that we have them is, of course, a wonderful thing from the standpoint of, this is the mission we're on. We're trying to help. People are coming forward. But it's a tragic thing that there are so many who are coming forward, and people we know who have yet to come forward, who have been harmed. And as I tell friends who ask, hey, Josh, I know you started a law firm. How's it going? My response is, sadly, it's going really well. We have spoken with, lots and lots of people. So as I mentioned, about 13 months of existence, we've spoken with approximately 60 individuals. That's a lot. If there were 60 cases going nationwide, that would keep, a law firm very busy. We were not able to take, or see that there was a case to be taken for each of those individuals. So we represent currently about a dozen detransitioners coast to coast in the United States. That's ranging from New England. We have matters pending in Rhode Island, New Hampshire. We have a case connected to Massachusetts. Coming on down the eastern seaboard, we have North Carolina, Tennessee. We have Texas in the deeper south. We have Arizona out west, an arbitration matter in California, a case we're about to file in Oregon, and then in the Midwest, we have a case pending in Ohio. So we have lots and lots of irons in the fire and cases that, keep us very busy in this cutting edge area of legal practice. Medical claims and claims for fraud, even in the medical context, are not new. But this type of claim where someone has been harmed in a way that the harm is what they were told was the help. They were told that what caused the injury was health care. That's the deception of, this is helping you. This is going to be the answer. This is the answer. You are getting better. when in fact, in some of our cases, the
Wow.
documents were showing psychological testing, there was a decline. In terms of, is this person getting better? No, they're not. But those facts were suppressed. Again, I'm not speaking to every single case, but in some of our cases, there was enough of active deception on the part of the doctor or the counselor that we are actually able to plead a fraud claim, a claim of deceit, because you kept relevant information from the individual. You did not fully explain to them what their options were. When you told them cross-sex hormones, testosterone injections for our teenage female clients who were teenagers at the time, when you were told that that was going to make you better, and they didn't explain exactly what testosterone injections can do and what your non-testosterone injection options are. Is psychotherapy a viable option? That was not fully explained. And of course, I know we'll get into this, but the lack of evidentiary basis and support for these medical interventions, and the fact that they are so experimental, and the ultimate effects, a lot of them are known, but so many of them are unknown, that was not fully disclosed. And so that's the overarching typical case of someone being misled into a path that was not what they were told it was. They were told it was helpful medical care and that this was the answer. But in fact, they had other pathways they could have taken. They had less harmful options. And because that was not fully explained and explored, and mental health evaluations were either short-circuited or in some cases completely dispensed with, mental health evaluations completely dispensed with. That's the feature, by the way, of one of the models. It's called the so-called informed consent model. There's a euphemism for you, where a patient signs a form and they're given testosterone, they're given estrogen without a mental health evaluation. And that's a feature of the program. You walk in, we give you a form, you sign it, you leave with these, powerful drugs. That's not okay. That's not proper medical care. And it's certainly not open and honest dealing in the doctor-patient relationship. So that's kind of the typical thing. And then, of course, the backdrop to all of this is these clients are deeply, deeply vulnerable. Many of them have sexual assault in their past. They have body image issues, some of which they're being, treated for at the time that they present to these gender clinics. They have, very serious anxiety, very serious depression. They may have borderline personality disorder, BPD. They may have OCD, obsessive compulsive disorder, where they fixate on, this idea of gender is my problem, when, as Dr. Hilary Cass recently, highlighted in her report, the gender presenting teen often has a number of mental health issues. And to focus in on the gender issue as the issue that needs treatment to the exclusion, or, not really taking into full account the full picture and the other issues that are there, is a huge medical problem. And so legally, we're able to step in with our experts who can give their expert opinions and say, this is not the correct standard of care. The standard of care was not followed because the individual was not given full information, and the process of how to care for all of their problems was not fully laid out and followed. And instead, gender was grabbed as the sole issue. They were pumped full of drugs, put on a path to ultimately have these harmful surgeries. And years later, they realized none of that cured my mental health problems. So it's very, very tragic, very, very sad. And it's remarkable to us how repetitive these client stories are, there is a very clear pattern in the mental health struggles they're going through, the vulnerabilities they're facing, the desperation that they're experiencing when they walk in. And they are turning to people that they are trusting at the highest level. This is the ultimate trust that you could place in someone: the medical professional, the doctor in the clinic, the counselor in the therapy room. I am trusting you to tell me what I need to do. And when that trust is breached, there's no greater harm in a way, because what was the person supposed to do? What is the patient supposed to do when they go to the expert, who they think is the expert, and follow that lead, what they think is full and frank expert advice, which, as I said, in many of these situations is simply misleading and not the full and frank expert advice they thought they were getting.
And another thing that comes to mind is just the lack of clarity about the nature of the condition. And, in a lot of these cases, it seems that the patient was given a kind of just so story about their gender-related distress. Like, well, because you are trans. Mm-hmm. And the providers do not offer the fact that this is actually a highly contested, like, trans isn't even a diagnosis. Gender dysphoria is a condition that can be brought about by so many things, such as other distress in your life, other mental health conditions, autism, same-sex attraction that you're feeling conflicted about. So there are so many reasons that a person might develop gender dysphoria. And in addition to not clarifying with them the unknowns of the medical interventions, they're not really given much clarity about what their condition means in the first place. Like, is that part of the informed consent picture that your firm is kind of painting about, like, the lack of true informed consent these patients are getting?
Absolutely. The lack of informed consent is really there every single case, because informed consent requires not only, the very basic boilerplate disclosures of, here's what this drug may or may not do, but just backing up and think about the recent WPATH Files video that we all saw, where the WPATH professional says the reason informed consent is really a fiction per se, a fiction across the board with a certain age group, a certain population, is their vulnerability, their immaturity, their lack of understanding of what it means to grow up as a woman, what it means to grow up and become a man, what it means to want to be a parent, what it means to want to have a sexual life. They're children. They are young, vulnerable, immature, and incapable of giving informed consent, according to this WPATH member on the video that was leaked with the WPATH files. So it's there in every case, because whether they're 14, 15, 16, 17, or on into the teen years or even early 20s, they're vulnerable. We know they have a history of mental health issues, this population. As Dr. Cass points out in her report, they've got a host of issues. We find that in our cases. Gender is not the only mental health issue the person is struggling with. It's all these other ones as well. So they need extra care and extra really clear explanations of what their options are. I was listening to an interview that Dr. Cass gave to the public radio affiliate in Boston. I believe it was her first interview in the United States. And her closing thought as to what would you tell a young person who is struggling, and this sounds like such intuitive common sense, but this is from, a renowned pediatrician, former head of the Royal Society of Pediatricians in England, keep your options open. That's what Dr. Cass said. Keep your options open.
Yeah.
And when you go down a medical path, it's a funnel. Of course, a funnel that's closing in on you and narrowing your options as you continue down the path, eventually placing you, and we have some very, very tragic stories from some of our cases about this, our legal cases, eventually placing you on lifelong dependent medical care. And if you do not have a life partner to face the rest of your life on lifelong medical care and lifelong mental health care, that is devastating. And we have a client who the medical records show said, if euthanasia is an option, this is something I would like to explore.
Gosh.
That's heartbreaking. It's absolutely heartbreaking.
Yeah. Yeah.
There's a lovely paper I read recently called the Child's Right to an Open Future. And, it's a lovely way of saying it. Like, it's our job as adults to make sure we don't foreclose and narrow the child's options when they're still childish and make immature decisions. I wanted to ask something about the numbers, because it's an issue, and I think you'll be able to answer a little bit about this. Because let's say, you said there was kind of 60 that kind of came through your firm so far, and we've over 220 detransitioners on our books in GenSpect. We run a service called Beyond Trans, and we offer funding for therapy and support groups for people who've been harmed by medical transition. There's over 220 on that. Now, it is international. And then it's whittled down to effectively 12. And we did do a webinar for Beyond Transitioners and it's freely available on YouTube, to help, literally a legal webinar for people who've been harmed by medical transition, to help them consider their options, consider their legal options. It seems to be that they have challenges. They have certain challenges. And I'd love you to kind of lay them out, because I know quite a few detransitioners. I've worked with them and I know them, and they can get deflated easily and almost collapse because the first lawyer maybe didn't see their case, or because something went wrong. And it would be great if you could just outline what are the challenges facing people who have detransitioned and who seek to take a lawsuit.
The biggest legal challenge, Stella, is probably what people call the statute of limitations issue. It's really the issue inherent to the way what's known as transgender or gender-affirming healthcare works. They're implementing this at such a young and vulnerable age. The person doesn't understand, they're told, and they believe, if they rely on what they're told, they really believe it, fully, that this is helping me. This is helping me. I mean, that's what allows them to sue, because they have relied on the representations that the medical team made to them. This will help you. They believe it. The patient believes it and goes through with the procedure. It's only typically years later. So a common fact pattern is 17, 18-year-old female goes on testosterone, has a double mastectomy, maybe even has her uterus and ovaries removed, which is, tragedy upon tragedy upon tragedy, harm upon harm. It's just complicating. And then a few years after that, or maybe the year after the hysterectomy, if it's such a drastic surgery, she will typically realize, oh my goodness, what have I done? This is not helping cure my mental health, discomfort with my sex, all the issues that are bound up in the mental health problems that they have experienced their entire life and presented with to the medical team. And in the usual case, continue to receive counseling for as well after the medical procedures have occurred. They simply realize this medical, as Dr. Cass warned and advised in her interview, I didn't keep my options open. I have really left myself with very little now to do. There's no other surgery to perform. I'm at the end of this medical road and I don't feel any better. So they don't realize, that's when they realize they were harmed. And it's years after the initial visit with the counselor, the initial testosterone prescription, the initial surgeries. It's years later. So this is an inherent problem. It's not the patient's fault. And that's what we have to keep reminding all detransitioners and people of good faith out there who feel like they were let down by the system. It's not your fault. You are the victim here. Your legal options are what they are, but that is not a reflection on you, and it's not a reflection on your diligence. Even though in the eyes of the law there is this fiction that a diligent person will figure it all out, really quickly. Oh, I've been harmed, and they'll run right to court. That's a legal fiction. That's something that the legislature is assuming when they pass these statutes of limitations, these legal deadlines for you to file suit. They're assuming that you will realize you've been harmed. Well, if I go in for an operation on my right knee and they operate on my left knee and I come out the next day, as soon as I wake up and I have my faculties, I will know I was harmed. They operated on the wrong knee. That's a very obvious mistake. When I go in for a double mastectomy and they remove my breasts, nipples are severed and reattached, it's a very, very sad situation, especially for a client we have who's now pregnant and finding, the extra pain and heartache of that procedure that was done. You come out of the surgery and you think, oh, it worked. I went in to have this surgery and, that's exactly what was performed. It must be fine. It's only years later when you realize that did not cure me. These mental health issues have persisted because medical procedures are not the answer to psychological mental health problems. At least that's what our cases are showing. And I know some of the systematic reviews show that as well. They don't find out until years later. So this is an inherent endemic problem. It's not the patient's fault. It's not their family's fault. They need to understand that. And if we're unable to help someone bring a legal claim against a specific doctor, we certainly can help them do other things. We can put them in touch with the medical board to file a complaint against that doctor. We can put them in touch with people like yourselves and say, go tell the world your story, to serve as a cautionary tale, try to make something out of this so that you can stand up for yourself and for others by speaking out. Maybe we could tell them to contact their local state legislator or member of Congress and try to get some of these laws changed so that if it's a medical situation where the patient isn't capable of understanding that they had a claim until years after the fact, well, then they should be able to sue years after the fact. And that is not a foreign concept to the law. The law understands what we call tolling, which means the deadline can be put on hold if someone is under a disability, if they're mentally incompetent, if they're of a certain age, usually a minor, if they have certain mental health issues, that can create an opportunity for that deadline to be temporarily paused, and then it will start running again once the person is back to their normal self and has been treated for the mental health issues. And so a lot of our cases, even though they're years later, we have arguments like this to make. We can say the person didn't discover the harm until years later, therefore, they should be allowed to sue, or they were incapable of discovering the harm until years later.
We hope you're enjoying this conversation as much as we are. We just wanted to take a quick moment and say thank you to all of our listeners. Your support helps us to keep the lights on and the mics hot.
We recently made the switch to Substack so we could build a more robust listener community. Visit widerlenspod.com and check out the different subscription tiers.
For those of you who are in need of parenting support and resources, we each have parent coaching membership groups. Plus, you can buy our book, When Kids Say They're Trans.
And if you're watching this on YouTube, don't forget to like and subscribe and get involved in the lively discourse in the comments section.
Thank you so much. Now, back to the show.
Can I ask a kind of other question about challenges that detransitioners may face? Something that really strikes me is that as opposed to one or two rogue surgeons or rogue endocrinologists doing some very, very bizarre out of the blue intervention, what's happened right now, and the Cass report obviously demonstrates this, is that entire hospital systems have engaged in these medical practices without the evidence to do so, without providing adequate informed consent, without really explaining to clients the nature of their condition or providing alternatives. So is that a legal argument that might be made on the other side that, well, AMA approves this, Endocrine Society approves this, or at least supports it? Like, what are the kind of other arguments that detransitioners would face in a lawsuit?
I think that's an important point, Sasha, to highlight. A legal claim by a detransitioner isn't just, I went through this process. It has to be something more than that. It's really founded on, I was mistreated, I was misled. If those factors are not there, there's no legal claim. So the way in which they were mistreated and misled involves getting very technical and very specific about what are these guidelines really saying and what is the basis for them. Okay, now that we have that clear, let's look over at what actually happened. What did the doctor actually disclose to the patient and actually act upon after that very insufficient disclosure, at least in our cases? So what we're finding is that first of all, this consensus you're referring to, I would say, is illusory in many ways. There's not really a consensus. When you drill down into the nitty-gritty detail, it's not the consensus that people would have you believe there is, number one. Number two, even as to some of these broad guidelines, say that WPATH or Endocrine Society put out there, what we're finding is in many cases, they are not being followed. So even if a lot of people say stipulate, let's assume that WPATH is putting out, good guidelines. And of course, we absolutely do not agree to that. But for the sake of argument, let's assume for the sake of argument that the guidelines are something that can be followed. They're not being followed. And let's take the mental health evaluation as an example. I'm thinking about SOC 7, and there's a paragraph in there where after all these detailed mental health evaluation steps and processes and guidelines, WPATH, in a completely duplicitous way, then proceeds to say something to the effect of the following. Notwithstanding all these mental health guidelines that we have just written above, please do not read us to be saying that we are not also okay with the so-called informed consent model piloted at Fenway Healthcare System in Boston. And so what they're saying is you can do a mental health evaluation or you cannot. It's up to you. In other words, what they're saying is these guidelines are absolutely meaningless. And if you can pick that up and read it, to a jury and read it to a court, and your expert is there to explain the duplicitous nature of what that's really saying, the whole house of cards falls right down, upon itself. And that's a really good example of, yes, we have this appearance and facade of a consensus, but it's really not a consensus. There are very different views, even within the group, on lots of details. And I think those WPATH guidelines really highlight the difference. And instead of choosing a side, is a mental health evaluation absolutely critical, or is a mental health evaluation totally unnecessary? WPATH says we take no position, ultimately. So that meaning there's no guideline at all.
Yeah, when we did the episode about SOC 8, when it came out, we talked about this because it's so arbitrary and it almost feels pointless to have gone through this kind of rigorous analysis of all these confounding variables that might be important to look at, and then to basically say, or you cannot do any of it. I mean, it's really bizarre, but it has the illusion of a well-written document with citations, with scientific sounding language. So if you're just giving it a quick cursory glance over, it can look like a normal document, but then you start to read it, which lawyers, you guys are the pros at reading between the lines and understanding it is something.
And can I add to that remember we discussed SOC 8 and they took away the ages of the minimum ages for various interventions such as mastectomies and some really quite severe and very brutal, I would argue, interventions. And they took away the minimum age requirements, and they admitted in their own conference that this was because basically for legal reasons, that for fear of being sued, we're going to take away these minimum age requirements. Effectively, they're being done and we don't want to get our clinicians in trouble. It feels so in plain sight, Josh, that I presume yourself and your colleagues who don't work in this almost can't quite believe your eyes when you start to study it and say, this is the Wild West. This is Mars in terms of following procedures in medical practice. That's what it looks like to me anyway, or Pluto.
It really is astonishing, and the evidence base aspect of this I think goes hand in hand with it, because the guidelines are built, and when I say built, I mean they're portrayed to have been built on a solid evidence base. And just listening to Dr. Cass's interview after having perused her report, her criticism, frankly, it was with her British etiquette, it was very politely said. It was scathing, absolutely scathing criticism, and scathing criticism of WPATH and its guidelines. And there was around this issue of a systematic review where WPATH says we tried to perform a systematic review, or I think they say something to the effect, based on my understanding of what Dr. Cass was explaining. WPATH says something like the following: a systematic review isn't really possible because there aren't enough studies out there. And then Dr. Cass said, well, if you really dig into it, they had a systematic review at their fingertips. I'm not exactly sure if they had actually commissioned it or not. Listening to her interview, it sounded like WPATH had actually commissioned it, done under Johns Hopkins, which they chose to ignore. And that is one of the reasons that Dr. Cass's team at the University of York, when they were doing their systematic review and was looking at WPATH's guidelines, rated the guidelines very poor. So for this to be held up as the gold standard consensus, I mean, what it is, Sasha, to your point earlier about how do you combat the idea of there is a consensus, we have to strip away the seal of approval that people are putting on there that basically is saying, look no further than our seal of approval and ask, what is it that you have actually approved here? Take the American Academy of Pediatrics 2018 policy statement. We have a case pending in Rhode Island on behalf of a client who is suing the American Academy of Pediatrics because the treating physician for her at the time was working with the AAP on this policy statement while he was treating our client. So our client was basically being used as the guinea pig to fluff up and make the policy statement look like it had some kind of legitimate basis, and absolutely not, because you look at Dr. Cantor's critique of the policy statement, where he looks at all the footnotes and sources and says this thing is based on a bunch of nothing as opposed to a bunch of solid evidence. And what's going on there? So that's our response. We take the big fancy seals of approval off the front page, and we start to open up. What does these things really say? What do they really mean? What is the evidence that's being cited to here? And what we're finding is inadequate, 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 inadequate. That is a breach of the standard of care. A doctor cannot you subcontract her obligation to treat her teenage patient and consistent with the standard of care in her medical judgment. She cannot subcontract that out to a big fancy organization with a big fancy seal of approval. She has to satisfy herself that what she is doing is correct. And if they've picked these things up and read them, they know they're not worth the paper they're written on. And the AAP itself, I believe in August of last year, finally came out and said, okay, we recognize the studies are insufficient to back up the policy statement, and we're going to commission a study or two, but we're not going to rescind the policy in the meantime. Full force and effect, plow ahead. Even though more study is needed, we're going to keep doing it anyway. Why?
Yeah, it's remarkable.
It doesn't make sense. Yeah.
Mm-hmm. And I mean, you're painting a picture that I think we totally agree with, that the entire foundation for these medical practices is totally not an evidence-based mode of treatment. We are curious, do you think that youth who transitioned or began a medical process as minors have a better case or equal case as somebody who transitioned as an adult? Because, in at least the kind of lay conversation, you hear a lot of people saying things like, well, for minors, obviously this is bad, but an adult can do whatever he or she wants. And as we've been discussing today, these medical procedures don't have a lot of evidence behind them, regardless of the age of onset of the gender dysphoria or the patient themselves. So can you talk a little bit, is there a difference between youth transition cases versus adult transition cases?
I don't think there's a huge difference. I will flag for everyone out there, all of your viewers and listeners, very counterintuitively, some states have actually created harsher deadlines for younger victims of medical malpractice. And this is all to, protect. Yeah, that's very counterintuitive. But this is to protect the medical community from what they would see as stale claims. So the younger the child is, in some states, the quicker you have to act to bring the claim. It's basically the parent's obligation, or, if the child is, above the age of 10 and under the age of 15. I mean, some of these statutes get very specific about the age ranges and the deadlines, and they shift as the child, gets a little bit older or is younger. So I just want to flag that as a very big issue. Do not assume if you were harmed as a young person that you have extra time. In some states, you may actually have less time. That's a very important point to make. It's very counterintuitive and we would obviously say unfair in many cases. But that's something that we should all keep in mind. With that caveat aside, we don't really view, a 17, 16-year-old case, person who starts hormones at that age versus someone who starts them at age 20 or 21 or 22 or has a surgery when they're 25. We don't view those cases very differently. And I would look at the title of the WPATH files paper as an example why. The title says something to the effect of the scandal involving young people and vulnerable adults. They're all vulnerable. Young people are vulnerable per se. Their youth, gives them the vulnerability. And of course, our clients have extra mental health issues on top of mental health issues, which adds to the vulnerability. Young adults, I would say, are also inherently vulnerable in many ways, especially as their brains continue to develop and, they have all of this new anxiety and life responsibilities as they come into their adulthood. That there's an element of baseline vulnerability there. But if they have mental health struggles, no matter the age, you're talking about a vulnerable population. And everyone who's going into a clinic seeking what they think is help for, discomfort with their sex and, gender dysphoria issues, they're vulnerable. So we see all of the cases very similarly, which is here is a vulnerable population. The fiduciary duty the doctor and the counselor, the surgeon have to these patients is as high as you can get because of their lack of understanding and their, extreme vulnerability. And if that trust is breached, there is a claim. So we really see it all as a very similar case, no matter the age.
In preparation for this interview, I was reading about, what are the extreme body modifications that are legal as such? And there was this guy done about 5 years ago. He was in England and he had a self-styled clinic called Dr. Evil's Extreme Body Modification Emporium. And he carried out some extraordinary interventions. He removed an ear, he removed somebody's nipple just because that's what they wanted. He gave somebody a forked tongue. Now, this guy did get done, but the reason why he got done wasn't because of those extreme interventions. It was because he wasn't a surgeon, he wasn't a qualified surgeon. But it started me thinking along those lines, and what was discovered in the WPATH files. And I'm eager to know, can somebody sue WPATH themselves, because all roads lead to WPATH. But the non-binary, the gender fawn, the people who are effectively new identities that have never been known before, not known in nature was the phrase that was used in WPATH. Is there a better case for those people who've had, let's say, nullification procedures? Some people have had, their nipples completely removed, or even their genital surgery made to look flat. These are extreme. Like we're wide-eyed at your man and his forked tongue. Brendan McCarthy is his name, and he did get done for it. But it's 5 years later, and it feels like these procedures are happening under the name of identity. And I'm wondering, have these people who had those extreme procedures, they're definitely vulnerable adults if they're having them, have they a better claim? Have they a stronger claim in your legal view?
I don't know. I would sort of go back to what I just said about no matter the age. To me, really, the shocking nature of the procedure shouldn't really matter, from a legal standpoint. If they're harmed, they're harmed. What I think you're honing in on, Stella, is perhaps the passé nature of this medical intervention concept of we're going to give testosterone to girls and estrogen to boys, and how, did that ever really make sense? And certainly I think it's making less and less sense as time goes on and you have this gender fluidity understanding. Some of our clients are, in terms of their sexual orientation, is across a spectrum. They may consider themselves bisexual or, questioning or homosexual, or they may not want to put a label on their sexuality, and perhaps even gender. But that just shows how, doctors and counselors and surgeons, the duty then is so heightened to do no harm. If someone is going to fluidly move from this identity to that identity, how in good faith and good conscience can we ever tell them anything is the right approach when it comes to permanent change. And that's the key. These injuries are permanent. And it goes back to Dr. Cass, keep your options open. If psychotherapy and, dressing a certain way, being gender nonconforming out in the world, really taking ownership of your persona and who you want to portray yourself to be, if all of those are, viable options, why are we going down the permanent medical, path of medical harm in order to chase these illusory benefits that study after study after study after study are unable to fully establish and prove as, the gold standard? I mean, in this country, we have the Food and Drug Administration, the US FDA. The FDA has not approved puberty blockers to stop puberty at a normal age for gender affirming care treatment. The FDA, this is very important, the FDA has not approved cross-sex hormones for gender affirming, we're going to make you look like the opposite sex or try to treatment. The FDA has not approved, these surgical interventions for the same purpose. So what are we, this is uncharted territory. This is highly experimental. We know it's dangerous and harmful. Where are the benefits? And that's really where we're struggling. In addition to representing detransitioners, our firm in medical malpractice cases, we have also filed friend of the court briefs in other cases around the country where states are seeking to regulate in this area, especially with regard to protecting minors. One of the friend of the court briefs we filed was in the United States Supreme Court in support of a regulation that Idaho has legislated for to protect minors. In a landmark ruling that hasn't gotten a lot of press, the United States Supreme Court on April 15th upheld the ability for Idaho to enforce its law, not with respect to the challengers in that case. I think it's 2 individuals and their families. They can access the hormones they're wanting. But with respect to everyone else in Idaho, all the other minors and children, the state is allowed to enforce its reasonable medical regulation and draw a line and say, we're not doing medical interventions before 18. Just a bright line. It's reasonable. It's evidence-based. It's consistent with Dr. Cass's warning of keep your options open. And you have the U.S. Supreme Court weighing in. It was a preliminary ruling, which perhaps is why it hasn't gotten a ton of press, but they're allowing Idaho to enforce that regulation. And that's really important part of the story. Our lawsuits are there to help individuals seek justice and to try to prevent this tragedy from happening to others. But legislation can also be the answer at the state and federal level.
Yeah, this is such a good point. And I'm very glad you clarified that, because there's so much happening so quickly that it's actually really challenging to keep up with the news. I mean, when we first started doing this work, there was like one thing that would happen every 6 months that we'd like celebrate, but now it's almost rapid fire. But before we move into our kind of exclusive content where we have some other really interesting questions for you, I want to make sure to ask you about this, because I think there's a lack of understanding, including with myself, about how does a firm like yours work, given that you guys just set up because you see this incoming kind of wave of people. And I understand that, some individuals have been generous to donate funds to your firm, which you use to pay people like expert witnesses and other fees. So can you talk a little bit about that? That way, if any listeners want to support the work that you guys are doing while these cases are still pending, they can do so.
Absolutely. We have a website, campbellmillerpayne.com, just like it sounds, or you can Google us and look it up there. But we have a donate button.
And we'll be sure to link it as well.
Yeah, we probably have a how you can help tab or something like that is where this is all found. But we have 2 big ways to help. One is for individuals to contribute towards expenses in our case, as you mentioned, filing fees, copying fees, travel expenses, expert fees, frankly, is one of the largest expense items that we have, because it's very important to educate the court and the jury on the science and the medical standards at play, and we need expert testimony for that. Related to that way to help, we have a separate how you can help for experts. That could be physicians, therapists, surgeons, any person of goodwill out there who feels that they have something to add. They can actually make themselves known to us through a form on the website and say, hey, I'd like to help serve as an expert on your cases. So those are two big ways to help. And like every plaintiff's firm out there, we are contingency based, so our clients do not pay us up front. The compensation we would receive would only occur on the back end if we're able to recover for them in some way, which we certainly hope to do, and believe that they certainly deserve that, given the extent of their injuries and the life ahead that they face as they pick up the pieces. And we're really excited to share some very significant news with you as well. And that is that in Prisha Mosley's case, which was the very first case we filed in North Carolina Superior Court, received a landmark ruling on just this week. We received word of the judge's ruling on April 29th, but we received a signed order this week, and we will have that published on our website in due course. And what the judge ruled is Prisha's claims for fraud, facilitating fraud, and civil conspiracy will proceed, and that she does have a legally viable case on those claims. So it's a hugely significant victory. As far as we know, this is the first ever substantive ruling like that in a detransitioner case nationwide. And it's a very big victory, and we fully intend to pursue those claims all the way to a trial if necessary.
Oh, that's such good news. Prisha spoke at the GenSpec conference in Denver, and her case, something about Prisha, I think everybody takes Prisha to their heart. But there's something really something very moving about Prisha having a happy ending, may I say, because it would be just so lovely to see some sort of vindication and acknowledgement of the great wrong that was done to her.
Absolutely.
We're thrilled that you were able to share that news with us.
And may I ask, just so to make sure that everybody is welcome, for example, same-sex attracted people, heterosexual people, all types of cases are welcome. And also, is there any sight of taking a class action? Because so many people ask me, why don't they take a class action? And I never know the answer.
Absolutely. All comers are welcome. We have clients, as I mentioned earlier, who would identify in terms of their sexual orientation across the spectrum. Your question about class actions, we get that a lot. That's a common question. Yeah. And that can be a very technical hurdle to meet. But loosely defined, yes, we see something like that in the future. It may not be a claim against individual doctors suing their individual patients necessarily. It may be something more about an organization. You mentioned earlier WPATH. We do have a claim pending in one of our cases against the AAP. You could see the manufacturers, if they're unfairly pushing a usage that's not FDA approved that they know is harmful, there could be potential claims there. We would have to investigate. I'm not saying that we have looked into that yet, but the concept is absolutely a viable concept. And so people should continue to feel free to come forward, to contact us through the website as we try to help them seek the justice that they deserve.
Yeah. It's been amazing to talk to you, and we'll be sure to link all the information you shared with us below. And it's something that I'd love to ask you about in our kind of special extended episode is, are there other legal precedents like abortion or euthanasia that can kind of shed insight into this? So we'll take it over there, but I guess we'll say goodbye for the kind of main portion today. And Josh Payne, we're really, really glad to have had you on. Thank you.
Thank you, guys.
Thanks for joining us this week on Gender, a Wider Lens.
If you enjoyed the show, please rate and review us on Apple Podcasts or Spotify.
And be sure to visit us on Substack by going to widerlenspod.com. There you can join our listener community, access bonus content and resources, plus learn about additional ways to support the show.
Our discussions are for educational purposes and are not intended as a substitute for mental health services.